I want to wish everyone a very warm welcome to SMIEO's presentation on restraint of trade agreements. We're also going to abbreviate it as ROTA, as the restraint of trade agreements, to say that every time we'll take this 1 hour session into a 2 hour session. Again, it's wonderful to have you here. I'm going to minimize this. And over here, can everyone see the restraints of trade? Can anyone see my slides? Devine, if you can just give me a thumbs up there. Yes? Okay, you can see it. Wonderful. All right. So protect your interest, retain skilled employees, and stay ahead. Restraint of trade agreements is one of those topics in which one is never sure, can I do it? How do I do it? Is it enforceable? How do I enforce it? What do courts take into account? And how is it that we can continue, as I say, protecting your interest, retaining skilled employees, and staying ahead in this regard? We're going to look at the welcome. We already did the welcome and the introduction. We are going to look at what is a restraint agreement, a ROTA. Okay. Are ROTAs enforceable? What can a ROTA protect? How to structure your restraint of trade agreement to ensure that it's enforceable? Which of your employees or job categories should be subject to a restraint of trade? I'm going to look at some case law. I'm not going to address case law. Reason being is we have an hour for this webinar, and we might, if there are interest in it going forward, do a longer webinar for 2 hours or so in which we can actually go through some cases. Then I'm going to ask you to ask me some questions. We're going to be interactive and look at it in general. Take notes, please. You're welcome to ask me any questions. There's a proverb that says the only stupid question asked is the one never asked. So keep that in mind. You're welcome to ask me questions afterwards, and also to apply it to your own workplace. So a warm welcome again for allowing SMIEO the opportunity to present this frequently talked about topic, the ROTA. There's an ever-dwindling number of skilled employees in the South African labor market, right? How are we going to address it by means of a ROTA? In order to protect your business interests and preventing poaching by competitors of your skilled employees, ROTAs are now more important than it ever was. Again, the only stupid question is the one not asked. So feel free to ask. You are more than welcome. That's why you are here. All right. So very, very a warm welcome again. What is a restraint of trade agreement? Now, always have it in writing. Follow the principle, but in general, in labor law, in your workplace, if it didn't happen on paper, it did not happen. So it is a written contract reduced to writing, usually between an employer and employee, whereby the employee acknowledges that the employee has a legitimate and protectable interest. Important here, protectable interest. In other words, an interest that is confidential, that is not open in the market for everyone to see. It's not public knowledge. It's a protectable interest, and the company would be prejudiced should the employee take up employment with a competitor and agrees to restrain his or herself from being employed with such competitors for a specific period of time and within a specified geographical area. So that is what a restraint of trade agreement is. In summary, it is an agreement between you and the employee in which you say, here is my defined protectable interest. You would normally say something like, during your employment with me, a company X, you will have access to A, B, and C, and X, Y, and Z, which are protectable interests, and you agree to restrain yourself from being employed from or with competitors for a specific period of time and within a specific geographical area, or you are restrained from disclosing that info. Although it's difficult to regulate that, but you are restrained from sharing that with anyone, especially competitors, which you're not allowed to 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 join. Need for a restraint of trade agreements. Why do you want one? Think about why do you want one? You shouldn't be very vague. A normal pitfalls is that companies cannot provide a protectable interest. They cannot prove that there is a protectable interest. So you need to be able to prove that you have one. It cannot be too broad or punitive. Okay? Please remember that. Another pitfall is there's an attempt to restrain junior employees that doesn't even have access to sensitive information. So be careful for that and do not delay enforcement because that might suggest the rota is not really necessary. So the need for rota is if you believe that your company has a confidential information and or trade connections, also important, that the employee would be exposed to, as I mentioned earlier, and should he or she leave and join a competitor, your company would be materially prejudiced. All right, that is a valid need for a restraint of trade agreement or a rota. I said I'm going to call it a rota, but I end up saying the whole phrase in any event. Another need for a rota is you simply want to protect yourself against the employee leaving and going to the competitor. That's the second one. The third one, and this is important, you want to retain the employee's skills. As I said, it's a very dwindling market with for or regarding skilled employees, and it's very important to retain the skilled employees, and a rota is a way of doing so. We are going to look at constitutional rights of employees going forward later on in this presentation, but this would typically be, these three bullet points would typically be what would justify the need for a restraint of trade agreement. Are restraints of trade enforceable? Here's a word that is probably one of the golden threads in a restraint of trade agreement or rota. It's tried law that rotas are valid and binding and therefore enforceable. Okay, number one. So is it enforceable? Yes. Provided that the rota is reasonable. Okay, so what you will need to prove in court, if there's a rota in place and the employee does not recognize the rota or comply with the rota, then in court, you simply have to prove that there was a rota in place and it was broken. Then the burden shifts to the employee or to the ex-employee to prove that that rota is reasonable. The onus is on them to prove that the rota is reasonable or not reasonable, unreasonable. But courts tend to balance the two, your rota and the reasonableness that the employee or the unreasonableness that the employee alleges, and to make a value decision then on whether to enforce the rota or not. We have seen an up in courts finding in favor of employers with rotas in this regard. But again, it is your responsibility to make sure that it is reasonable. You cannot, for example, do a rota and have someone restrained for 10 years. That is not reasonable. If the nature of the position does not justify you saying that you cannot work in South Africa for a period of 12 months, it is not going to be valid. There is going to be a an example mentioned later, but I'm just going to jump to that now. We can speak about it again later on. For example, a mechanic or a hairdresser that works in a specific area, Cape Town, for example, even smaller, Bellville. They work in Bellville and they leave the employ. The restraint of trade, if that restraint of trade says that you're not allowed to work in the Bellville or surrounding areas or in a 10-kilometer radius from my shop, that is reasonable because that will mean that they will poach clients if they work in that area. So that would be fine if you say that you cannot, for a period of 12 months, work in a 10-kilometer radius from my shop. If you, however, say you cannot work in Joburg for a period of 12 years, in other words, in the whole of South Africa, that turns into an unreasonable rota. Because, again, value added, will that have an effect on your shop in Cape Town or not? No, it would not. Because people will not drive all the way to Joburg to look after or to go after the mechanic that worked at your premises. So bear that in mind. It must be reasonable. Reasonable. So what is reasonable? What is reasonable? The questions are asked that, does the employer have an interest that deserves protection? Again, a protectable interest. You will see I ask or I do mention the same things more often than not in this webinar, because that is what the key words are in the rotas. Okay, so you have to look at, do you have an interest that deserves protection? Do you have a protectable interest? If so, is that interest threatened by the employee? Is that interest threatened by the employee? All right, you have to look at, again, a value a judgment regarding whether that interest is threatened by the employee. Number two. Number three, if so, does such an interest weigh qualitatively and quantitatively against the interest of the other party not to be economically inactive and unproductive? And number four, is there an aspect of public policy having nothing to do with the relationship that requires that the restraints of trade be maintained or rejected? So those questions will be asked by the courts to see whether your restraint of trade is reasonable or not. And we will need to have to answer this. Okay. Is there an interest that deserves protection, a protectable interest, a reasonable one? If so, is that interest threatened by the employee? And if so, does such interest weigh qualitatively and quantitatively against the interest of the other party not to be economically inactive and unproductive? Because the Constitution also says you've got a right to take part in the South African economy. So that also is taken into account. And is there an aspect of public policy having nothing to do with the relationship that requires that the restraint be maintained or rejected? Did I have a hello? Did someone try to get my attention? You can put up your hand. No. Okay. Sorry, I thought I heard hello. Yeah. As I mentioned to you earlier, the court makes a value judgment on whether to enforce the restraint. Sorry, if I could just ask you that everyone mutes themselves.
Sorry about that.
That's fine. If you can just mute yourself, that would be great. Thank you so much. I appreciate it. All right. Continuing, the court makes a value judgment on whether to enforce the restraint and considers three important policy considerations in determining the reasonableness of a restraint of trade. Number one, the public interest that requires that parties should comply with their contractual obligations. In other words, regarding reasonableness, the rule in Latin is pacta servanda sunt. In other words, you signed the restraint of trade, so you are bound by it. Okay, that is the rule there. So you signed it, and because of that, that is why you should be held by it. All persons should be productive and be permitted to engage in trade or their profession. As I said earlier, everyone is allowed to take part in the South African economy. However, point number three, the extent of the trade, does it go further than necessary to protect the interest, the protectable interest again? So it is very important that if the restraint is in place, it should be reasonable and it should not infringe on any person that has the right to be productive and be permitted to engage in trade or their profession. Okay, so that is important to look at as well. What I would suggest here is if you drafting tips for the restraint of trade agreement. Oh, sorry. Let's go to this one. What can a restraint of trade agreement protect? Now, I want to talk to also what a restraint, how to make sure you can enforce the protection of what's written there. Use very clear and specific wording. Be very clear. Don't do it too vague, as I said earlier, and simply say that all and each and every information that you would be involved in is protected and cannot be disclosed, or you cannot go to the competitor. So you need to be very specific and identify what constitutes confidential information. Be sure you define the geographic scope and duration narrowly. Consider including separate clauses for non-solicitation and confidentiality, that they can't contact your clients or staff, and if they do contact them, they should not refer, or they should refer them back to you, and review the clause periodically, because your protectable interest might change, because businesses evolve, and as businesses evolve, the restraint of trade there might be more protectable interests, which necessitates an updated restraint of trade or ROTA agreement. So what can a restraint of trade agreement protect? We are going to look at confidential information, protectable interests, again, supplier restraints, duration of restraints and geographical limitation, and payment in consideration for restraint. That almost never happens, but it's possible. In other words, you tell the employee you are not allowed to go to a competitor for 1 year. And because we ask you that, we are going to give you 1 million rand for the year that you're not going to take part in the South African economy. That is a valid or reasonable restraint of trade. All right. If it had not been for we will pay you 1 million rand, that rota might have been seen as not valid. So very important to take that into account. So let's look at each of them. Oh, excuse me. Confidential information. Now, there's no hard and fast rule to this. Each case will be judged on its own merits. All right. So, for example, 12 months is applicable for most industries, but 2 years might be too much for certain other industries, except if that person is a very senior or a very strategic employee in the business, and the restraint of trade or the rota necessitates a longer period of time. I explained to you the common pitfalls in this procedure, so I'm not going to go through that again. I want to also just talk about the enforcement process. If an employee breaches a restraint, what should you do? What should you do? The employer may approach the High Court for an interdict. The court may enforce the whole restraint of trade agreement or parts thereof, and costs normally follow the losing party. So it is very important to make sure that the juice is worth the squeeze if we look at restraint of trade agreements and how it is drafted and what effect it has on the company. So confidentiality, it's same as disciplinary inquiries. There's no one rule. It is each case on its own merits. So what is confidential for business A might not be confidential to business X. All right. So confidential info really, that's why it's so important that you do a value audit on your company to see what is confidential information and ask us to assist you to draft the rota to protect the protectable interests of the company. So it'll depend on the facts of each case. It'll depend on the facts of each case. All right. If your supplier is a, a company or a retailer that's available to everyone, and you say that you're not allowed to buy there anymore, even if it's open to the public, then it makes no sense. However, if you've got a certain supplier that you only agree or only work with, and there's a price list, special price list for you, that's something different. That is confidential info that can be restrained. All right, so it's very important to look at that as well. Importantly, the employer must be able to prove that the employee obtained such information in the course of his or her employment at, sorry, obtained in the course of his or her employment, and that's not public knowledge or in the public domain. What I mentioned to you earlier regarding the retail shop that is public information and open to the public, the employer cannot restrain someone in that regard. So importantly, again, the employer must be able to prove the employee obtained such information in the course of the employment. It's not public knowledge and it's not in the public domain. So that employee, in other words, would not have had knowledge of that specific information if they weren't employed at your establishment. So that's what you will need to prove. That is confidential info. So to summarize this, there's no hard and fast rule. That was confidential for the one may not be confidential for the other one. It'll depend on the facts of each case. Each case must be judged on its own merits. And importantly, the employer must be able to prove that the employee obtained such information in the course of his or her employment, not public knowledge or in the public domain. Again, there's a balanced approach to make sure that reasonable restraints is upheld, where unreasonable restraints might not be uh, uh, protected. So remember, you cannot necessarily, that you can reinforce protection through confidentiality agreements, non-solicitation clauses, and garden leave provisions, but yeah, keeping it away from clients. So important to take that into account as well. The starting point is to determine whether it is confidential. Okay, we spoke about that. Critical questions you need to ask yourself regarding this. Is the information that the employee was exposed to not available to the competitor in the first place? This talks to the previous point that I made, that if it's public knowledge or in the public domain, then it's not really confidential information. So is the information that the employee was exposed to not available to the competitor? If the competitor also bought his equipment at shop Y, then it is what it is. Then it's not an enforceable confidential information. Would it be to the advantage of the competitor? So if the employee or if the competitor, I just ask there that the mic be muted.
Oh, I keep losing.
I think that helped. Yeah. Yeah, I think that worked. Right. Would it be to the advantage of the competitor? In other words, if the competitor has that information, will it assist them? Your information. If the competitor has access to the information that you want to restrain, would it be there to the advantage of the competitor? Then it's no longer public information or public knowledge. Then it is your trade secrets or your client lists that would be to the advantage of the competitor, which you then need to restrain. That is reasonable. If it fell into the hands of the competitor, would it give the competitor an unfair advantage? That's quite important to take into account. So, together with the fact that would it be to the advantage of the competitor, one needs to look at if it fell into the hands of the competitor, will it give him an unfair advantage over you? All right, that is reasonable if you can answer yes to that. And we mentioned this earlier. You'll remember when I mentioned that the employee must have received access to that information whilst in your employment. Same here. How did the employee acquire such confidential information? If it was from you, great. Then restraint of trade is applicable. It must be of economic value to the employer seeking to protect it. If it does not have economic value or value to you to protect it, a restraint of trade will not assist you. Okay, so we must be able to prove that it is of economic value to you seeking to protect it. Then the onus is on you. The burden of proof, the onus, is on you to prove that such information is confidential. All right, so it's your responsibility to make sure that in court, when you search for the interdict, when you apply for the interdict, you must be able to prove that this is confidential information obtained during the employment at my establishment, which will be to the advantage of my competitor, and that'll give my competitor an unfair edge over me because it's my info. Okay, you need to prove that it's confidential information. Important, the employer does not have to prove disclosure or use, but only the possibility that they could do so. So it's a two-folded one. They either have to prove that the person did not, or the employee or the ex-employee failed to honor the restraint of trade agreement, or there's a real possibility that they could do so. Bear that in mind. An undertaking by an ex-employee not to disclose is irrelevant. A simple undertaking by an ex-employee, I will not disclose it. No, it has to be in writing and it has to be specifically drafted with the correct wording, not vague, making sure that you note the protectable interest very clearly and in which geographical area are we looking at restraining the employee to operate in, and for what length of time, for what period of time. Okay, because those are the two things that the restraint of trade will talk to. For how long is it applicable and in which area? The risk of disclosure will be obvious if employed by a competitor. Loyalty of an employee to a new employer and therefore an opportunity to disclose is always there. That really talks to the fact that there's a real possibility that they can do so, and therefore one can enforce the restraint of trade agreements and make sure that your protectable interests are indeed protected. We are going to look at examples of confidential information. Typically, what is confidential information? What are protectable interests in your company that you need to specifically word in your restraint of trade agreement? You see that's how everything links together. Okay, confidential information, you need to make sure that it's protectable interests. You need to make sure that it's specifically noted. You need to make sure that you can justify that you're saying you cannot enter into this industry in the Gauteng area or the Western Cape area for X amount of time. You need to make sure that you can prove that, and you can prove it as reasonable and put it in your restraint of trade agreements. Examples of confidential information. Now, this list is not an exhaustive one. All right, you can give me that this might not be applicable on you, or others might be applicable on you. So this is examples of, oh, sorry, customer lists and databases, obviously. Okay, your customer lists and your customer databases, if that falls in the hands of the competitor, it's got what we said earlier, economic value for you, and if it goes into or comes into their hands, it'll give them a competitive edge. It will assist them. They're going to contact your clients, and they'll have a negative economic impact on you. That's why it's so important to make sure that you mention that specifically in your restraint of trade agreement. Costings. What are your costings? That is a protectable interest. That is confidential information because it talks to rands and cents, and you might have a specific arrangement with a supplier or a vendor, and you talk to that on a daily basis, and if disclosed, it will give the competitor a competitive edge, an unfair advantage. As I mentioned, pricing, discount structures, profit margins, that's confidential. That's confidential because if your competitor knows what your profit margin is, they're going to obviously undercut it and get the business. All right. So pricing, discount structures, and profit margins, very important, are protectable interest, confidential information. Designs and specialized products that gives you the edge, that has an economic value on you, for you, sorry, that makes you unique. Designs and specialized products, that is confidential information. If it falls into the hands of the competitor, they will design the exact same thing and it'll not give you the edge you had before that. That is confidential information. Contractual terms with clients. What terms and conditions do you have with your clients in the contract that you have with them? That is confidential information. If it falls into the hand of the competitor, if it's disclosed to them, it'll give them an unfair advantage because they will change it to be more favorable and it will give them the competitive edge. All right, so contractual terms with clients is seen as confidential information worthy of protection. And information received by an employee about business opportunities available to the employer. So if the employee receives information about business opportunities available to the employer, in other words, possible clients, possible business, and that falls into the wrong hands, that employee is not allowed to disclose that to the competitor, as it will give that competitor, again, the competitive edge, which is not, which is a protectable interest and confidential information. NB, importance here. The employer must show that the information is worthy of protection. Okay, so what you did now is you did a restraint of trade agreement, you went to, or the person left your employ. Now you want to go to the High Court to get an interdict, to interdict that person from following through to join the competitor or to disclose information to that competitor. The court will inquire to the nature of the employment relationship and the position employed. Where confidential information is habitually handled, such may impose a higher obligation of confidentiality. Okay, so that is a question that the courts will look at. They will look at the seniority of the employee. Obviously, if it's a senior employee, the restraints of trade will be more applicable to them, right, than the junior employee that we spoke about earlier. The nature of the information itself. Is it public information? You see how this repeats itself, how this links into one another. The nature of the information itself. Is it information publicly available to everyone, or is it information that falls under this, for examples, these examples? Costings, design, specialized product, contractual terms with clients, information received by an employee about business opportunities available to the employer. So they will look at the nature of the information itself and whether the employer impress on the employee the confidentiality of the information. In other words, do you have a rota in place? Is there a restraint of trade agreement that says that this information, A, B, and C, is seen as confidential information that you were privy to because you took up employment with me, and that is why it is a protectable interest, and that is why it's confidential information. So you should impress it on that employee. If there's no restraint of trade agreement, that person has got carte blanche to do whatever they want to, wherever they want to. Okay, so you need to make sure that it is impressed on the employee. And you also have to look at whether the information can easily be isolated from other information which the employee is free to use and disclose. So they are looking at the information itself. Can it be isolated from other information which the employee can actually use and freely disclose? So it's important to look at that distinguishment there. Protectable interest. Some questions there. Is customer or trade connections a protectable interest? Is customer trade connections a protectable interest? Yes. Customer information, definitely. Trade connections, maybe. It can be that you've got trade connections with a public retailer, which is not necessarily a protectable interest, but customer, yes. Customers, definitely. Is the information that the employee was exposed to available to the competitor? In other words, was it public knowledge? If not, or if so, it's not a protectable interest. The purpose of employing a person and remuneration is to build such customer connections. A complex web of personal relationships between employee and customers. If that exists, that is a protectable interest, and that needs to be restrained. They cannot disclose that information, customer information, with the competitor. Very important to note, the court recognizes that such is open to exploitation by ex-employee and competitors. So they do recognize that fact. The employer must, however, show that the employee's relationship with the customer is such that when employee leaves, he could easily induce the customer to follow him or her to a competitor. So very important, you need to prove that that customer or that employee must be interdicted because in the High Court, because they can induce the customer to follow him to a competitor. That goes to customer lists almost. And what about customers brought along by the employee? What about that? You join a company, you bring clients over. Is that clients the companies or is it the employees? It'll be the companies. And it'll form part with a prior point. You must be able to show that the employee's relationship with the customer is such that when the employee leaves, the customer will follow. So that goes with, what about customers brought along by the employee? It remains your customers, your employees, and they can be interdicted from going into that. Supplier restraints. Now, this is different to a competitor. In certain limited circumstances, such a restraint may be enforceable or reasonable. You must still show that you cannot buy from that supplier because it's a protectable interest. The commercial relationship with the supplier is under threat if it is disclosed. So a disclosure of pricing structure for clients to the supplier, all of that is seen as a protectable interest. So make sure if there's a supplier restraint that you mention that in your rota to say that you will have access to our suppliers and the price, the commercial relationship, how we work together. And because it's seen as a protectable interest, it is confidential information and it can be included in a restraint of trade agreements. Do you see how many things one needs to take into account? It's not just a slap bang document, a generic document that you give to an employee and then it covers everything. It really gets very technical when you have to go into detail regarding protectable interests and the confidential information and the restraint of trade, the geographical area which it applies to, as well as the time frame. We need to justify that, and that is judged on a case-to-case basis. Duration of restraint and geographical limitation. The period of restraint must be reasonable and logically linked to the interest that requires protection. So you are not going to say, you may not for a period of 5 years not work for me or not work in the same industry. That is unreasonable. Okay, you need to, if you say it's a year, that might be more reasonable. It depends on industry to industry, but it must be, again, the key word there, reasonable, and linked to the interest that requires the protection. It's dependent on the nature of the restraints and the protectable interest. The nature of the restraints and the protectable interest, the time period may vary. For example, 12 months to 5 years. If you want to make it 5 years, I've never really seen one for 5 years or drafted one for 5 years, but it might be that your industry is so niche and so unique that it requires the duration to be for 5 years. So the duration must be, again, the keyword there is reasonable. It must be relevant to interest seeking to protect. Again, it must be reasonable. And for example, here's my example that I used earlier. Hairdresser versus technical manager or technical designer. If you say to a hairdresser, you cannot work in South Africa for an X period of time because of the restraints of trade and our client list, that'll be unreasonable. But a technical manager or designer that can work for any company around South Africa, any company, a hairdresser will can steal clients if it's in a certain radius to the ex-employer. A technical manager or designer can work anywhere. And that is why if you say there that in South Africa you cannot work as a technical manager or designer for a competitor, that might be reasonable versus telling a hairdresser you cannot work in this industry all across South Africa because they won't be able to take clients with them all over South Africa. So be sure, this is just an example of what you should take into account. It must be relevant to the interest you seek to protect, and it must be reasonable. Again, reasonable. You must be tired of these words already, but that is what must be taken into account. I mentioned to you earlier that there is payment in consideration for the restraint. So there's no legal obligation to pay any consideration for the restraint. My advice would be to just do the restraint of trade as simple as possible, as detailed as possible, and not say that you can sit home for a year, but we will pay you an X amount. That seldom happens. So rather do a proper restraint of trade and make sure you can enforce it. Protecting your company against competition, is that a valid reason to conclude a restraint of trade agreement? Protecting your company against competition, is that a valid reason to conclude a restraint of trade agreement? No. A restraint of trade agreement cannot be used simply for the sole purpose to prevent competition. All right? It's what I mentioned earlier, to give them an unfair advantage. That's a problem. But for the mere fact that's an example I use now. The rota cannot be used simply for the sole purpose to prevent competition, because competition will always be there. Okay, so if you use a restraint of trade agreement, it must be not to give them the unfair advantage, not give them info they would not have been privy to had it not been for you, but to simply prevent it will not be a valid or reasonable rota. A rota will only be enforceable if it's intended to protect, again, a legitimate interest. I want you to remember these words: legitimate interests, a protectable interest. How to structure your restraint of trade to ensure that it is enforceable. Personalizing a restraint of trade for your company's specific needs. All right, again, each case on its own merits. Identify the confidential information Exposure whilst employed. What is the confidential information that the employee will be exposed to in your employ? Mention that, identify it, identify the protectable interest, identify the supplier restraints, identify the duration of the restraints and the geographical limitation. Very important. If you do not, they will simply say, nothing prohibits me from doing so, I can do what I want to, which will have an adverse effect on you. Identify, specify protectable interest in the rota and or annexure thereto, and identify, if need be, if you want to take this route, payment in consideration for the restraints. Again, apply the reasonability test because the courts will apply it, as I mentioned to you earlier, what they will take into account when looking at the restraints of trade and whether it was enforceable or not. Which of your employees or job categories should be subject to a restraint of trade? Now, here's simply questions that needs answers. A sales rep. So if you think about objectively and reasonably, a sales representative, should they be subject to a restraint of trade? The answer there would probably be yes, because they have information about your products, about your customer list, and they might be able to give that information to a competitor, which will give them a competitive edge. Sales manager, the exact same thing. A pattern maker. Now, this really depends on, is it a generic pattern versus a specific design, as I mentioned earlier, that is specific and unique to your industry? If it's not, no rota. If it is, have a rota. A technician. A technician. They might have info as to your specific designs that you use, so they can be interdicted. They can be form part of a restraint of trade, unless it's a technician, for example, a mechanic that works on cars and works on a that is the only exposure they have to your confidential information. Then no. A sample machinist, if that machinist creates designs, rota might be applicable. If it's simply a machinist that does work as and when it comes through, then no, no restraints of trade. So it's a value judgment the whole time that you need to take into account. Accountant, yes, that person might have protectable information at hand in dealing with your books going forward. Again, if they simply did the normal creditors, debtors work, it might not be applicable. So I'm mentioning this to you so that you can see what the two reasonability test really is. A designer, this is quite important. If you had the design and there's a design unique to your business, then that designer can be restrained. If it's a designer that designs information or designs that is in public knowledge or in the public arena, no, you cannot. Factory manager, not necessarily. HR manager, not necessarily. Because they work with people, and people in each individual in organization really works with what they have at hand, and there's no real information that they are privy to that will form part of a protectable interest. Unless they are exposed to it, then a rota can be applicable. Case law on the topic. Now, this has been coming for quite a while, where protectable interests are judged, and we need to look at why and how was it handled in the workplace and in the courts itself. Now, this is just a few that I want to bring to your attention that is applicable on restraint of trade agreements, in which they said that restraint of trade agreements is applicable, and the interdict was successful when it was reasonably drafted and it was broken by the employee, and also where the employee could prove that it was an unreasonable restraint of trade, and therefore it's not, the courts found it's not applicable. Now, I'm not going to go through each of these cases, as I said, because we don't have time for it. and I'm seeing it's already almost 5:02, and I want to open up for question and answers here as well. So these are the cases to give you an idea. It's a lot, and this is just but a few of them. So restraint of trade, that's why it is such a technical issue, and that is why you need to really jump through hoop to make sure your restraint of trade is applicable, reasonable, and enforceable. Now, FAQs, interactive and in general, sorry. Section 22 of the Constitution gives employees the right to choose a trade, occupation, or profession. All of us have that right. Now, does a restraint of trade not infringe on this right? Does it not say you have the right to choose your trade, occupation, or profession? Does it not stop that? The enforcement of the restraint must not nullify the employee's ability to work. So they must always have an ability to work. You cannot say you might not work, you're not allowed to work. Okay, the entering into a contract is part of economic life. It's a freedom to contract. All right, the ultimate test, again, is the restraint reasonable? And if so, it may pass the constitutional muster. So, very important, it must not simply restrain someone from working. There must be a reasonable reason for it, warranting that specific contract or restraint of trade in your workplace. So, very important to take note of that there's a constitutional right to work, but if it's reasonable, it may pass that constitutional muster. Now we've come to 5:2 and we've got some time for questions from the floor. Any questions that anyone has for me? I'm looking at Larissa Hills. Larissa Hills?
Hi, Johan. Thank you very much for the informative session. A question from my side is with regards to enforcing or invoking your restraint of trade when it comes to employees that have left the organization. If can the organization choose who they want to enforce the restraint of trade upon? So, for example, you have had sales executives that's left the organization and gone to a specific competitor. And then you also have other skilled employees that has also left the employee of the organization and has gone to the competitor. The company then chooses to only enforce the restraint of trade, not on the salespeople, but only on the technically skilled people. What are your thoughts around that?
My thoughts around that is you need to make sure that you apply restraints of trade consistently. Because if you don't apply it consistently, it might not pass the constitutional reasonability test. So be sure to make sure that you apply it consistently unless there are reasons that you don't want to apply it to them. Perhaps the restraint of trade agreement does not include them because of the seniority level, and there are others that they do apply to because of the seniority level. Then I would suggest do it, but be sure to do it as fairly as possible.
And as consistently as possible.
And as consistently as
possible. Okay, and then just my second question.
Yes.
What are the implications for the employer if the restraint of trade is very broad and very vague?
If the restraint is very broad and vague, then the courts may find that it's not specific enough and therefore it's not reasonable. So you need to be sure to, in the restraint of trade agreement, make sure you mention what information is requested or not requested, applicable, why it is applicable, and address it thoroughly. It can't be, if it's too vague, you're not allowed to work because of you will have access to information in the workplace, and therefore it doesn't specify what information. It simply says you will be exposed to information and therefore you cannot work for a competitor, that might not pass the reasonability test because you need to be sure to identify the protectable interests.
Thank you very much, Johan. You've answered my questions. Thanks.
Thank you, Larissa. Thank you for asking. Are there any other questions from the floor?
Johan, please just have a look in the chat. There's questions.
Oh, I did not see that. Let me check. I'm just going to open this so that I can open the chat area.
Johan, can I ask a question in the meantime?
Is it Chris?
It's Chris, yes.
Yes, Chris.
We're in a very specialized field, rotating equipment, and we take on youngsters and we take them through a learning curve, 3 years, 4 years, 5 years. We have people that's with us for 10 years because it's a specialized, how can I say, services, rotating equipment. And then companies close by us wait until these guys are on a certain level, and then they offer them more money, and we just lose all that expertise. Now, how can we put a restraint of trade together or, yeah, in place to prevent them to go to that's now a very fine line, because you mentioned that you cannot stop people from doing their trade, but yeah, they jump ship, and we did all the hard work. We gave them the training on machines, on how to fit bearings, how to analyze a machine, to assemble it. Is that something that we can protect?
So is it information that they have that can affect your company negatively, or is it more a matter of you spend too much money on them to upskill them, and because of that you actually lose money?
There's two reasons. These people go to specific sites where they work on specific machines. And now if my opposition take them, they also have the expertise to then steal my client away from.
If that is the case, and they've got access to training, and that might infringe on a protectable interest, which is your customer or your client list, yes, then you can include that in a restraint of trade agreement. Also, don't forget that you can mention to that, or you can put a training agreement in place where you say, if you leave within a certain period of receiving the training, we are going to deduct that from your final pay if you leave our employ.
Yeah, can I say you can leave me, but you're not allowed to work at my customer base?
Yes, because that is your customer list.
And what if the opposition also have, or say it's Mittal. Mittal is very big.
Yes.
And Mittal is now my client, but also my opposition's client.
Okay.
Now, how would that work?
So, for example, you are both, I'm just making an example, subcontractors on the same site. So both of you have the same client.
Yeah, but on the same site, but not on the same equipment.
Same site, but not same equipment. And that person has access to information that will give your competitor the chance to work on that equipment.
Yes.
Yes. No, then you can follow or put that in restraint of trade agreement.
Okay. Thank you so much.
Thank you. I'm going to the just to the chat zone. Oh, sorry. Can a rota be applied to employees falling under a bargaining council or a main agreement? Yes. Yes, they can definitely fall under that. Caleb, Johan, what is the difference between a non-disclosure agreement and a restraint of trade agreement? Oh, good question. So the question here is, what about a non-disclosure agreement and a restraint of rota? Let's just say rota. So the non-disclosure agreement can be applicable to any agreement in which the terms of that agreement is confidential and no one will do the non-disclosure, or no one is allowed to know what the agreement pertains to, and that is why a non-disclosure agreement is signed. So a non-disclosure, all restraints of trades, for example, will include a form of a non-disclosure agreement, but not all the non-disclosure agreements are necessarily restraints of trade agreements, because it can simply be an agreement, any agreement that parties agree, a settlement agreement, for example, wherein parties say we're not allowed to disclose the terms of that agreement. Then there's a question again here. Is this also applicable to sports coach at schools? That's going to be a difficult one. Reason why I say so is normally sports coaches they already have a specific skill set when they enter into a company or a school, but they won't necessarily be privy to information that can be regarded as protectable interest. However, if it is a sports coach that has access to clients or people, children that only come for coaching at that school, personal coaching, for example, and that person leaves and take that children with them or that people with them and coach them at another school, then it's clients that are stolen. Then you can do a restraint of trade to say you're not allowed to coach any of our pupils at other schools. So then it can be. So again, it's a value judgment. Are there any other questions? Pleasure. Remember, the courts lean towards a balanced approach. They uphold reasonable restraints where real business interests exist, but will not protect employers seeking to stifle competition unfairly. So that's important to note. If there are no further questions, I want to tell you that, or I want to thank you for giving SMIEO the opportunity to assist or to present the webinar to you. And if you've got any questions or you need any further assistance, you're welcome to contact me at jvandyk@smio.co.za. jvandyk@smio.co.za. I'm going to just repeat it again, then I'm going to stop my screen share and just address you guys, jvandyk@smio.co.za, and we can assist you. So, ladies and gentlemen, I thank you. Thank you for attending. To assist us in making sure we present the best webinars that we can, I will ask you to just drop your feedback in the chat zone, your feedback on the webinar itself. It'll assist us greatly, and I thank you for attending. And if you have anything else, if not, you're welcome to leave the meeting, and I thank you again. It's been a privilege.